Hello, everybody. This is Attorney Augustus Corbett, and I want to come back to give you another update on the Derek Chauvin murder trial. I've been updating you periodically. I've been keeping up with the various witnesses and what they've had to say so that I can come and keep you abreast of what's going on. My mind has not changed in terms of how important this trial is to the African American community. It is the most important civil rights trial in our generation. Now, I did several updates back when Byron Allen had his case against Comcast, and I talked about how important his case was to civil rights. But quite frankly, when it comes to sort of a life and death analysis, when it comes to African American men actually dying, I think this supersedes the Byron Allen civil rights case for the reason that I just gave. Because again, if Chauvin walks after this trial, it could put a lot of black men's lives in danger. We already find ourselves in danger with law enforcement now. But if this man is able to walk from this trial, despite the mountain of evidence, then I think it could increase the dangerousness that we African American men face. So I think that essentially this is not just a trial of one rogue cop, which is what a lot of the police officers and cops who are testifying against him would want us to think, including the African American chief of the Minneapolis Police Department. This is not just a rogue cop. In fact, the policing in America is on trial. And it's for that reason that we need to stay abreast of what's going on. So let me give you an update of what's happening with this trial. I think things are still going well for the prosecution, quite frankly. I think they're doing a good job. The defense has made some progress on cross-examination, but not a lot. Now, I've told you in previous videos that what the defense is trying to do, and how would I know what the defense is trying to do? Because I'm a criminal defense lawyer. This is what I do every day. And what he's trying to do, and I know exactly what he's doing, he's trying to essentially raise doubt in the mind of at least one person. He's also trying to get certain concessions from the state's expert witnesses and even some of the fact witnesses so that he can come back during closing argument and include those concessions in his argument. Because one of the things that we can do in closing arguments is make inferences. We can argue inferences from concessions that we were able to get during the trial. So he just want to be able to just throw out things during his closing argument. For example, he want to be able to throw out and make inferences that basically Mr. Floyd died from a drug overdose or from a bad heart. He doesn't care if the state's expert witnesses agree with him totally or not. He just wants them to concede certain things. And so he has created these hypotheticals and are asking the state's expert witnesses to agree with those hypotheticals. And then just based on those hypotheticals, he can then make inferences from those hypotheticals to create reasonable doubt. And all he needs to do is create it in one witness's mind. So what he's doing, his overall strategy is to make this the George Floyd trial instead of the Derek Chauvin trial. He's trying to make it all about George Floyd and not about Derek Chauvin. And he's made some progress toward that. And keep in mind, he hasn't even presented his case yet. He still will get the opportunity to present his case in chief after the state rests. I believe they're going to rest this week. I'm being told that the early part of this week, the state will rest this case, and the defense then will get a chance to start calling witnesses that are favorable to its theory of the case. But make no doubt about it, the defense has a lot of ground to make up in its case in chief, a lot of it. Now, I watched several experts give testimony last week, and I think they did fairly decent. Let's start with Dr. Martin Tobin, a highly qualified pulmonologist who specializes in breathing and has 45 years of experience and still practices medicine in the Chicago area. He really took us to clinic. I mean, he took the jury and the courtroom to clinic about breathing and the cause of death for Mr. Floyd. And what he essentially said was that Mr. Floyd died of a low level of oxygen, which is also called asphyxia, and that caused brain and heart damage. And the asphyxia, the low level of oxygen that caused the heart and brain damage, is due to 4 factors, he said. 1, being in the prone position. Mr. Floyd, as we all saw, was on his belly, handcuffed, lying on cement. And so therefore, he couldn't fully expand his lungs to get air. And that was one of the contributing factors to the low level of oxygen. Another was the fact that he was, in fact, handcuffed. That puts him in a position where his lungs cannot expand. Also, Chauvin's knee on Mr. Floyd's neck also obstructed his ability to get air into his lungs, and the knee on the back prevented him from being able to breathe deeply to get air into his lungs. And one of the most riveting parts of Dr. Tobin's testimony was he showed how Mr. Floyd was even using his fingers, his knuckles, to pry himself up by putting his knuckles on the tire of the police car and trying to pry himself up so that he could get air. Dr. Tobin said he was essentially trying to breathe with his knuckles and fingers. And he also said that drugs and or heart disease did not cause Mr. Floyd's death. Now, on cross-examination, the defense did exactly what I told you earlier. The defense used a lot of hypotheticals, but in my opinion, did not get very far, especially with Dr. Tobin, who has all this expertise. I mean, this man has spent 4 decades studying breathing. He's a pulmonologist, which means he studies the lungs, essentially. And specifically, he's studying the part of the lung that has to do with breathing. So if you are not someone who has that sort of expertise, you're not going to be able to cross him up. You're not going to be able to get him to, to contradict himself. I mean, he was very impressive with his calculations and his scientific data and his research and all of that. So I don't think that the defense was able to get much from Dr. Tobin. But again, he's going to continue. He continued to cross-examine Dr. Tobin and the other experts to raise reasonable doubt and to confuse the jury. Then the next expert, another one who testified, let me see if I can pronounce his name, Daniel Eisensmid. He's a PhD, a forensic toxicologist. Forensic means that he not only studies and practices toxicology, but that he also understands how it relates to the law. He has been in his profession over 3 decades. And basically he testified that Mr. Floyd had not overdosed on fentanyl, as the defense is doing everything it can to suggest that he did. Mr. Floyd did not die from fentanyl. Dr. Tobin, as I told you, said that he died, and nearly all of the experts agree that he died from asphyxia, not an overdose of fentanyl. The toxicologist also testified that Mr. Floyd, the level of meth in his system was very low, not even enough to make him intoxicated from the level of meth. So the defense was not able to get very much from Dr. Eisensmid. Then there is Dr. Linda or Lindsay Thomas. It's either Lindsay or Linda Thomas. I think it's Linda Thomas. She's a medical doctor. She's a forensic pathologist. Again, forensic means she knows how to testify in court, basically, and use her expertise in criminal or legal cases. Let me say it that way. And as a pathologist, she studies causes of death. She studies body tissue and that sort of thing. She's a medical doctor, but she doesn't treat live people. She comes in after people are deceased, and she studies the decedent's cause of death, etc. And incidentally, she helped train the medical examiner who did the autopsy on Mr. Floyd. And in her medical opinion, she agreed with the medical examiner and Dr. Tobin that the cause of death in the autopsy, it was stated this way. The medical examiner said the cause of death was cardiopulmonary arrest complicated by law enforcement subdual, restraint, and neck compression. So basically, all that means is the medical examiner determined that Mr. Floyd's heart and lungs stopped working because law enforcement had subdued him, restrained him, and was compressing his neck. And she also testified that the mechanism of death was, again, asphyxia or low oxygen. On cross-examination, once again, the defense was doing everything it could to just get her to concede on certain hypotheticals so that he could make inferences from those hypotheticals in his closing argument. I thought it was pretty ineffective. Then Dr. Andrew Baker testified. He is the actual medical examiner who did the autopsy. He's a medical doctor with over 3 decades of experience. His, again, determination was, as I said earlier, he said the cause of death was cardiopulmonary arrest complicated by law enforcement subdual, restraint, and neck compression. Once again, it just means that law enforcement's neck restraint, neck compressions, restraint, subduing him, holding him down, knee in the back, knee on the neck, all of that caused Mr. Floyd's heart and lung to stop working. He said that he found in his autopsy that Mr. Floyd, yes, had a bad heart. Yes, there were drugs in his system, and that they were contributing factors, but that they were not direct causes of death. The defense is going to really work that angle big time in its argument, having the medical examiner to just simply point out, yes, there was a bad heart. Yes, there were drugs in the system. However, those things, and those things contributed to Mr. Floyd's death, but they were not direct causes. And from what I'm hearing from lawyers in the state of Minnesota, it is not necessary that the state proves that asphyxia caused by law enforcement actions is the only cause of death, but that it is a contributing cause of death. Well, they got more than that it contributed. They got from the medical examiner that it was the direct cause of death, despite the equivocations that the defense lawyer is doing everything he can. And by the way, he has a job to do. I get that. I've been in tough trials myself. I understand that he's got to put forth a defense. That's what he's getting paid to do, and so he's doing his job. It's very unpopular. It to me seems just out of place. I find it offensive. But again, he has a job to do. I can remember one trial in particular where we had to sort of go at the victim ourselves while the family, the victim's family was in the courtroom. It was not pleasant. I did not like doing that, but I had to bring out certain facts about the victim in defense of my client. So I'm understanding of what the defense lawyer is doing, but again, it is not pleasant from my standpoint. And then the ER doctor who tried to resuscitate Mr. Floyd, Dr. Bradford Langenfeld, he also pronounced Mr. Floyd dead. He testified that he also believed the cause of death was asphyxia. Not the drugs, not the bad heart, asphyxia. So every expert that the state has presented, and when I say expert, I'm talking about the medical experts, every one of them. There was even a police surgeon from the Louisville Police Department who also testified that it was the actions of the police officers that caused Mr. Floyd's death. So as expected, the state put forth many well-qualified medical experts who all came along and in a collective way attributed the death to asphyxia caused by the police officers. So the state has had a very good run at it. The first week or so of the testimony, if you recall, there were fact witnesses who were basically standing out there begging for Mr. Floyd's life. That was very emotional. They did a very good job of explaining why they were out there begging for Mr. Floyd's life. That was the kickoff of the trial. But as I told you in previous videos, that the trial would switch from videos and emotions and get to the experts. And that's where we are now. And we're getting ready to go further into the experts because the defense is going to begin to call medical experts who are going to refute the experts that the state presented. I'm sure that they're going to also call use of force experts, that is, experts who have expertise on when police officers can use deadly force, whether the use of deadly force in the George Floyd case was reasonable. So they're going to have those kinds of experts and probably many others. So this is far from over. This is far, far from over. Although the state has done a great job, it's far from over. Just the nature of trials and the outstanding things about this trial, the fact that the victim is black, police officer killed him, white police officer at that, a victim who had drugs in his system, who had health issues, a victim who's accused of committing a crime. All of those factors very well will come into play and could very well cause at least one of those jurors to just not be able to find it in their hearts to find this police officer guilty, which could result at least in a hung jury. So we don't know. It's hard to predict. It looks like a good case for the state, but no one knows what those 12 people are going to do. And in this case, in these types of cases, the defense just needs one of them. Reminds me of the Walter Scott case in Charleston, South Carolina. The police officer was on video shooting Mr. Scott in the back several times, killing him as he ran away without any weapons, posing no threats whatsoever to anyone. And there is a very famous U.S. Supreme Court case, the Tennessee v. Garner case. Go to the YouTube channel if you're not already there. Search for the video that I did on whether the police can shoot a fleeing felon. And you'll see what I mean about the Tennessee v. Garner case. There, the U.S. Supreme Court said no, police officers cannot shoot a fleeing felon, cannot use deadly force on a fleeing felon who poses no substantial risk of death or substantial body physical harm to the officer or to anybody else. Mr. Scott did not pose any kind of a threat to anyone. He was unarmed, had nothing. They found nothing. Although it did appear that the officer tried to plant something beside Mr. Scott's body, Mr. Scott had nothing. He had nothing to harm anyone. Yet a white juror said, I just cannot find this officer guilty, despite the evidence, despite the video. So I'm concerned that he still could walk. Here we have, in Dallas that is, we have seen officers get convicted. There was a conviction in the Bolton John case. There was a conviction of a police officer in the Jordan Edwards case. And there was another conviction in another case here. That is unprecedented. It's exceptional because in most of the cases, police officers are not even prosecuted, let alone convicted of killing anyone, especially black male victims. So we'll see. Let's hope for the best in this case. Let's hope that the state does get a conviction. That feels kind of weird for me to say that because I'm a criminal defense lawyer and I'm typically on the side of the defense. But in this case, look, first and foremost, I'm an African-American male and I have a son and many male cousins, friends, etc. And I know that if Chauvin gets away with this, that's going to send a message to the police across the country that they can kill black men under almost any circumstances, video or not, and get away with it. Impunity. That is not the message that we need to be sending right now. Period. All right? So I will be coming back with other updates, but that will get you up through the trial starting tomorrow. It'll restart tomorrow, Monday, unless there's some unforeseen contingencies or motions or whatever. The defense is constantly going to bring up different motions and so forth to try and, slow this thing down or tilt it in its favor. So barring none of that, tomorrow the state will continue its case, and I believe it'll close. It will rest its case either Monday or Tuesday, and then the defense will start presenting their case. All right? Keep checking back. Keep checking back for more updates. Thank you for tuning in. Bye.